All right, everybody, we are back with the third subsection of our Section 9 Juvenile Justice Public Policy section. And here we're going to talk about kind of different kinds of juvenile justice policy, right? What different kinds of criminal justice policies have we used specifically when looking at juveniles and juvenile crime? First one we're going to talk about are curfews. And these are relatively common. Again, they're not everywhere, and everywhere they do exist, they're slightly different. But basically, a curfew says that if you're under a certain age, sometimes it's 16, sometimes it's 18, sometimes it's 14, you have to be either inside or with a parent at some specified time, right? So, there might be a jurisdiction where if you're under 14, you're not allowed to be outside after 8 p.m. unless you're with a parent or a guardian or some kind of thing like that, right? Now, there are lots of problems with these curfews, right? The idea here is that if juveniles aren't out and about kind of at night, then they won't be able to get into trouble, commit these, vandalism and, all the other things that kids are likely to get up to when out and about after dark. But there are lots of problems here. Number one, they're difficult to enforce, right? Because unless I have a driver's license on me, which, many juveniles don't, how do you know if they're 14 or 15? If 15 is allowed to be out after a certain age, but 14 is not, and a police officer kind of catches somebody who's around that age, how are they going to tell whether they're actually 14 or whether they're actually 15? It can be very difficult to figure out, right? An 18-year-old and a 17-year-old look very similar. So unless they have some kind of driver's license or other identification on them, if they say they're above 18, how do you know, right? So they're difficult to enforce. Another big problem is if there's some kind of abusive situation going on at home, being at home is kind of the worst place for them to be, right? Maybe they're out and about at 9, 10 p.m. because if they go home, their drunk father or drunk uncle is going to hurt them or sexually abuse them or something else. So these kind of curfews can actually make life more dangerous for juveniles. And when, there's been lots of kind of criminal justice research about these curfews, and kind of the conclusion is that there's really no evidence that they're effective at all. There's no evidence that they reduce juvenile crime. There's no evidence that they kind of prevent juveniles from doing whatever it is they're going to do for lots of different reasons, including the ones I just discussed. So curfews don't seem to be effective at all in changing juvenile crime. Now, the second thing we're going to talk about is diversion programs. And these diversion programs, again, there's dozens or hundreds of these around the country. But the basic story here is, instead of going through the juvenile justice, the whole process and getting sentenced and sent to a juvenile detention facility or whatever, you get sent to some outside organization that does some kind of something, rehabilitation or something. And if you complete their program, then, either the charges are dropped or your sentence gets commuted or whatever. And again, there are tons of different kinds of these. But one of there are lots of problems with these, but lots of successes too, right? One of the issues with these diversion programs is usually you have to plead guilty in order to be eligible for one of these diversion programs, right? So if you're a juvenile who's been arrested for a crime you didn't commit, and they say, hey, we'll kind of let you off without any kind of record or punishment or whatever if you complete this diversion program, you might think, well, I didn't do it, but I'm not confident in being found not guilty if I have to go to trial or an adjudicatory hearing. So I'll just plead guilty to this, do this diversion program, which I'm pretty confident I can complete, and then I won't have any record of this, and it's the easiest way to make this go away. Problem is, that's going to result in a lot of kind of false confessions and false guilty pleas because this requirement to plead guilty is a requirement to be going off in these diversion programs. You can do these diversions either pre-charge or post-charge. So essentially at the beginning of the process, before it goes in front of a judge and they get found guilty and, you know, all those things, or after. So there's lots of different stages in the process where you can have this opportunity for diversion. And there's positives and negatives for both, for, you know, doing it earlier versus doing it later. And sometimes it's, you know, kind of set up in the system itself, depending on your jurisdiction, that it, you know, you can only do them pre-charge or you can only do them post-charge. Some areas, kind of the judge gets to decide. If the judge wants to give this diversion option early in the process, they can. If they want to wait until kind of, you know, sentencing time, they can do that too. And it all kind of depends on what jurisdiction we're actually discussing here. But the overall kind of lesson from these diversion programs is there's a huge variation in their quality, in their philosophy, in their effectiveness, right? So there are some of these diversion programs that seem to be really good at preventing recidivism, and they seem really good at kind of teaching juveniles the skills to stay out of trouble and helping kids turn their life around. And there are other ones that are, you know, research shows are essentially a complete waste of time. They're not helping. In some cases, they might even make things worse, right? So it really depends on what organization we're talking about, what kind of crime we're talking about. Is this a minor status offense, or is this, you know, relatively minor delinquency, like a, you know, burglary are we talking about here? Or are we talking about just running away from home? Are we talking about, you know, problems with alcohol or drugs? And then, you know, the age of the juvenile. I mean, there's huge amounts of variation in what programs help, what programs don't, whether they're effective or not effective in reducing recidivism, whether they're effective or not effective in kind of helping that juvenile, you know, complete school and all these different things. So the ones that seem to work the best are hopefully the ones that politicians and criminal justice officials are going to kind of push towards. But it takes a lot of research and a lot of effort to kind of figure out what the good ones are and what the bad ones are. So this is a very slow process, kind of weeding out which diversion programs are good and which are bad, and which we should support more and which we should support less. But it is ongoing, and things are slowly getting better. Now, waivers. We've discussed this a little bit in kind of previous subsections, but this is where you take a juvenile that is under the age of adulthood, but because of the nature of the crime or because of, you know, the juvenile's prior record or whatever, we're going to say, hey, we're going to send you to adult court to be tried as an adult, even though you were under the age of majority at the time of the crime, right? And there's usually some minimum age that juveniles have to be before they can be waived at adult court, right? So it's, again, not all of these categories exist in every jurisdiction, but kind of a general way to think about this is between the age, you know, between birth and some age, 8, 10, somewhere in there, you can't be held criminally liable at all. And then between that age A, where you can finally be held criminally liable, and age B, you have to be kind of held liable in juvenile court. So maybe it's 8 to 13. If you're going to be held criminally liable, it's going to be in a juvenile court. Then from age B to age C, you're kind of default in juvenile court, but you can be waived to adult court. So say age 13 to 18. Default, you're going to go to the juvenile system, but you can theoretically be waived to the adult system. And then, of course, once you're after that age, which again is usually 18, you go straight to the adult system, right? Now, these waivers have lots of problems, and they're used differently in different states, different jurisdictions. But no matter how they're used, there is no measurable deterrent effect. Using waivers or not using waivers, jurisdictions that use them often versus not having them at all, has no apparent effect on juvenile crime. So, just like adults, juveniles are not sitting there making a rational decision like, should I rob this convenience store? You know, the possible penalties, here's the possible benefits. And they're not making logical choices to commit this crime knowing what the odds are that they're going to get caught and knowing what the punishments are and everything. So whether they could theoretically be tried as an adult or not really doesn't affect their decision-making process. So there is no real deterrent effect of these waivers towards juveniles. Now, most of the time, in jurisdictions that allow this, if a juvenile gets waived to adult court and they get found guilty, in some jurisdictions, the judge has the kind of opportunity to either sentence them as an adult, like they would in an adult court, or they have the opportunity, since this is a juvenile that was waived to adult court, to sentence them as a juvenile. And in those states or in those jurisdictions where judges have that options, in 71% of cases, juveniles waived to adult court were still sentenced as juveniles, right? So even judges kind of see this waiver process, according to this statistic, as kind of overused and not beneficial for that particular juvenile. All right, teen courts. This one is kind of an interesting one. This is kind of sort of a diversion program. In fact, when you look up a lot of like juvenile justice textbooks and stuff, they discuss these teen courts under the diversion program process. But others kind of separate them out as a separate thing. And this is where the kind of entire juvenile court process is done with a lot more input from the juvenile's peers rather than just other adults. And the thought here is that juveniles kind of see adults as different and out of touch and not like them. But if the process can go forward with a lot more input, where a lot more of the actors in the, every stage of the process are actual peers, other teens, then they're much more likely to have kind of both emotional and psychological kind of buy-in to the process and see it as much more legitimate. And so in these teen courts, they'll have teens that are, the jury members, sometimes even like judges and prosecutors and defense, and they'll have kind of lots of different roles are with other teens, sometimes former defendants that have turned their lives around, that kind of thing, and not some 70-year-old judge who doesn't know the first thing about being a teenager in this day and age, right? They also often have the victim involved to do kind of victim impact processes to kind of make this juvenile offender see how their crime affected the victim negatively. And it gets a lot more focus and buy-in and is seen as much more legitimate by juveniles going through this process because the people around them are much more like them, right? And the good news is there's a pretty decent evidence for this being effective. Obviously, this is only used for relatively low-level crimes. This is not going to be used for, armed robbery and murder and such. This is going to be used for, minor status offenses and, misdemeanors, that kind of thing. But it seems to be effective at reducing recidivism and helping teens get back on track, with education and with, getting jobs and all the things we kind of want them to do as society. One of the downsides of this process is that there's some evidence that it's resulted in what's called net widening. And this is where, a case that prior to these teen courts would have just been dismissed. The intake officer or whoever plays the role of prosecutor in that system would have seen this and said, look, this isn't worth our time. This isn't that big a case. This isn't that big a deal. So we're just going to dismiss these charges. We're going to let this kid go home. But because these teen courts become an option, now they're going to say, instead of let that kid go home, let's send them to this teen court. So that might be one of the reasons why we're seeing better outcomes, is because the juveniles who go through these teen courts might have been the ones who wouldn't have gone any further in the process anyway, i.e. the ones least likely to recidivate anyway, right? But overall, there seems to be some pretty decent evidence that these teen courts are effective in kind of helping teens turn their lives around. Of course, the kind of largest, most impactful implication or policy choice at the end of a juvenile justice case is placement, i.e. taking the kid away from where they're living and making them live somewhere else. This could be detention, this could be foster care, this could be a residential health facility, could be lots of different things. And it's really tough to do this. It's a very difficult decision to make, to take a child away from living with their parents or their grandparents or their, whoever their guardians are. And in some cases, it seems to be better than leaving them there, but not others, right? So, for instance, if a child is being abused at home, either physically or sexually or however else, if a child is being abused in their home, it is better to take them out of that situation and put them, say, in foster care. They have better outcomes. Still not great, but better than they would have if they were left at home in that situation. If they have some sort of severe mental health problem or have experienced some kind of really major trauma, it's better to put them in foster care than it is to put them in some kind of mental hospital or residential treatment facility. Foster care seems to be the better case there. But outside of any of the above, it seems to have worse outcome than just leaving them at home. Leave them with their parents. Even if that's not the best possible scenario, even if their home life has lots of problems outside of abuse or some kind of major mental health issue, leaving them at home is kind of much better overall than taking them out and putting them, say, in foster care or detention or whatever. So this kind of removing a child from their home is important, but it should always be used kind of as a last resort. It should always be kind of the default, outside of documented abuse, outside of major mental health issues. Kind of the default should be to leave that child with their parents or whoever their guardians are, because that has much better outcomes the vast majority of the time than taking them away from that situation. All right, that is the end of Section 9, all about juvenile justice. Thank you so much for watching. I really appreciate you guys.